Private law governing relationship and legal obligation among individuals or group. It comes crucial aspects like contrast, inheritance, ownership, and family matters. In Rwanda, located in Central Africa, Rwandan private law is shaped by historical, cultural, religious, political, and economic influence, notably in adapts to the dynamic landscape following the impactful event, particularly in the Rwandan genocide in 1994, reflecting the evolved societal, political, and economic change in the country. So, hi, my name is Revian Jedha Arhansyah from English for Legal Studies Kawan 304 Tuesday. This is a video presentation on Rwandan private law. I will be accompanied by some important people explaining it. So, let's go. History of Rwandan private law.
The history of Rwandan private law can be divided into three main periods: the pre-colonial period, the colonial period, and the post-colonial period. Pre-colonial period. Before the 19th century, Tutsi kings governed Rwanda. Private law was based on flexible customary practices, overseen by elders, chiefs, and judges. It addressed aspects like marriage, divorce, inheritance, and ownership, drawing from diverse sources. Colonial period. Late 19th to early 20th century saw Germany and Belgium imposing a rigid, codified private law, ignoring Rwanda's diversity. Enforced by colonial authorities, it favored colonizers, displacing existing sources. Post-colonial period. From the 1960s, post-colonial Rwanda shaped a flexible, codified private law based on national legislation reflecting Rwandan values and harmonizing various sources. Enforced by state authorities, it prioritizes dignity, equality, solidarity, and reconciliation.
Discussion of Rwandan private law.
Rwandan private law, governed by the 2018 Civil Code and replaced the previous Civil Code of 1988, comprises 4 books: Persons and Family, Property and Succession, Obligations and Contracts, and Evidence and Prescription. The code addresses key aspects of private law, including legal rights and obligations. 1. Persons and Family. This book addresses the legal status and capacity of individuals, civil registration, identity, documents, nationality, citizenship, marriage, divorce, matrimonial regimes, property relations between spouses, filiation, parentage, parental authority, child protection, adoption, foster care, guardianship, curatorship, family mediation, and family counsel. 2. Property and Succession. This book covers property classification, acquisition, and transfer, along with the rights and obligations of owners and possessors. It addresses co-ownership, condominium, servitudes, easements, usufruct, lease, rent, pledge, mortgage, succession, inheritance, wills, donations, and the liquidation and partition of the estate. 3. Obligations and Contracts. This book covers sources and elements of obligations, their performance and extinction, assignment, subrogation, novation, remission, joint and several obligations, conditional and alternative obligations, divisible and indivisible obligations, contractual and extra-contractual liability, general and special rules of contracts, formation and validity of contracts, interpretation and integration of contracts, effects and execution of contracts, modification and termination of contracts, breach and remedies of contracts, and specific types of contracts like sale, exchange, donation, loan, deposit, mandate, partnership, agency, brokerage, bailment, insurance, and arbitration. 4. Evidence and Prescription. This book addresses rules and methods of evidence, admissibility and evaluation of evidence, burden and standard of proof, presumption and admission of facts, written and oral evidence, testimonial and documentary evidence, electronic and scientific evidence, oath and confession. It also covers the concept and function of prescription, computation and interruption of prescription, suspension and renunciation of prescription, and specific periods of prescription for various types of actions and rights.
So, what is the conclusion?
Rwandan private law, governing relationships and legal obligations, encompasses critical aspects like contracts, inheritance, ownership, and family matters. Shaped by a complex history influenced by factors such as culture, religion, politics, and economy, Rwandan private law has evolved, particularly in response to the transformative events after the Rwandan genocide in 1994. Based on the 2018 Civil Code, replacing the 1988 version, Rwandan private law is organized into 4 books. These books comprehensively regulate persons and family, property and succession, obligations, and contracts, and evidence and prescription. Notable trends and challenges include the harmonization of diverse legal sources, modernization to meet societal changes, the promotion of human rights in private spheres, and efforts towards reconciliation and restoration of private relations impacted by the 1994 genocide and subsequent conflicts.